Do you have questions about probate, wills, things like that? Well, check out this video because we're going to be talking to a attorney all about probate, and we're going to get started. What's up, everybody, and welcome back to All Things Tennessee with me, Ben Barreto, your local real estate pro and relocation expert for East Tennessee. Today, we're going to talk with LuAnn Hellman at Melrose Title all about probate. LuAnn is an attorney at Melrose Title Company here in Knoxville, Tennessee that handles a majority of the sales transactions that I do in my business. And again, she's an in-house attorney. She deals with probate, and she's going to help us navigate what probate is and how to go about approaching it, and hopefully answer those questions that both you and I have when it comes to probate. So this is a Zoom interview, and we're going to jump into that right now. What's up, everybody? It's me again, Ben Barreto. I'm sitting here with LuAnn at Melrose Title, and today we're going to talk about probate. There's a lot of misinformation out there on probate, and I'm not an expert on it either. So instead of me trying to answer those questions, I want to go straight to someone who understands and knows this, and that's going to be LuAnn. So, LuAnn, if you want to take a second, introduce yourself and tell people why you're an expert in probate, and we'll kind of take it from there.
Thanks, Ben. I don't know if I'd call myself an expert, but I am well-versed in probate. I practiced at a firm. I handled some probate when I first got out of law school, and then I have been handling real estate transactions for about a decade now. So very, very well versed in the probate process. And again, my name's LuAnn Crass. I'm with Melrose Title Company. I'm one of the attorneys in-house for Melrose.
Okay. And what does Melrose do? What is the title company? Let's talk about that real quick.
Okay. So we help facilitate the closing. So basically, when we get an order, we're going to go out to the Register of Deeds and the other public records, and we're going to search and make sure, very, very basically, make sure that the person who says they own the property actually owns the property, and make sure that the buyer, whenever we transfer the property, gets clear title. So there's no liens or encumbrances on that property.
Now, one thing I'll get, and we'll get to probate in a second, but one thing I get a lot of questions is in some states, when people handle title, when they handle sale of real estate, they deal with attorneys. So when I get calls from people that are from out of state, for example, coming to Tennessee, they always ask me if they need to get an attorney, and I tell them no, the title company is going to handle it. And just to clear that up, when the title company handles it, there are attorneys in the background doing work.
Generally, every title company is associated with some law firm. Melrose is a little unique because we have two attorneys in-house, so we're a little bit easier to reach than some that just associate with a law firm. But generally speaking, there's an attorney behind the scenes working on the documents. Okay,
so if that's a question for anyone watching this right now, attorneys are involved, and so everything is being done. Contracts, all of that's being checked by attorneys and being done probably in a way you're used to. We just call it a little bit different, refer to it a little differently here in Tennessee. But when we're talking about title, we're talking about the same thing. All right, so we're here to talk about probate. Now, probate, my understanding of probate is basically how a property is handled if someone passes away in the court system. But that's really the only general idea I have about it. So I do get calls about probate. I know that there are people out there dealing with probate and they don't know where to start. And it's probably a scary situation if you don't know, how to approach it. So I guess the first question I have is for you to answer is, what is probate? How would you break that down to a layperson?
Okay. So yeah, typically when someone passes away, probate is the legal process that we use to basically ensure that their estate is distributed based on the way that they want it via the terms of their will, or if they didn't have a will, then based on state law. And it is a stressful time for people. I mean, they've just lost a loved one, generally speaking. So they've just lost someone. They don't know what to do. The probate process is typically the first thing you do is you go to the courthouse, you get an appointment with the clerk and master, you file a petition to open probate either with a will or without a will, and then someone's going to be appointed as the personal representative. Now, one key thing I want to mention here is the personal representative is not necessarily the person who's allowed to sell that property. That is a common misconception. If there's a will, 90% of the time, the personal representative is not directed to sell that property. There's beneficiaries. So, for example, say mom passes away, she leaves the property to her 2 children. One of those children is appointed as personal representative. Those children were left the property, so both would have to sign. The only way that a personal representative can sign without someone else is if there's very specific language in that will that directs the personal representative to sell the property and then distribute the proceeds amongst the beneficiaries. And then the other thing that happens at the start of probate is generally a notice to creditors is issued. And what that means is if there are known creditors, that notice is sent out to those creditors to say, hey, this person has passed away. If you have a claim to make against the estate, you need to get it filed within your 4-month creditor claim period. And then it's also published in a newspaper of general circulation in that county.
You mentioned first a person's will versus state law. So does a person's written will always trump state law, or can there be situations where state law may trump a person's will?
So the will would trump, but the caveat being the will has to be authenticated by a Tennessee probate court. So we've had a scenario, for example, where a person passed away in Georgia and they opened probate in Georgia, but she owns some property up here in Sevier County. Well, they hadn't opened probate in Sevier County. And so they ended up having to open probate again, and it's called ancillary probate, and have that will authenticated in the Tennessee court too, so it could pass under the terms of the will rather than under state law.
Okay. Is that something that's pretty complicated as far as authenticating a will?
It's not complicated. Typically, a person would want to, hire an attorney to help them through the probate process. But I know there's scenarios where people can't afford to do that. And so the register of deeds in the county where the person lived, I'm sorry, not register of deeds, the clerk and master in the county where the person lives can help walk the person through opening probate. So basically they take that will that the person left to the clerk and master and say that they want to open probate, and the clerk and master will help them through that process.
Gotcha. And you're saying that it should be done in the scenario you talked about, the person lived out of state, but the property was here in Tennessee, so it should have been authenticated here in Tennessee.
Yes. So in order for that property to transfer under the will and not under state law, then that will's got to be authenticated in the state of Tennessee too, not just Georgia.
Okay. So I guess the next question I have is probate always necessary?
So that's a very good question, and I have a very lawyer answer for you, but it depends. So when I teach the probate class that I have, I always break it down into 4 scenarios. So the first scenario is if there was no will and the person has been dead for longer than a year, then probate is not necessary. And the reason is if probate is not open, then the creditor's claim period is 12 months. So they can file a claim and force probate open within a 12-month period. Well, if it's been longer than 12 months, that creditor claim period has run, and so any claim would be barred. So if it's been over a year and there's no will to authenticate, then there's really no reason to open probate. We would just have affidavits of heirship signed and recorded at the Register of Deeds office, and we'd proceed that way. Scenario 2 is if there's no will, but the person has not been dead for a year, then it kind of depends. If the person's been dead for, say, 11 months, then it may not really make sense to open probate because your creditor claim period is going to run in a month. So if there's no will to authenticate, there's not really a reason in that scenario to open probate either. But if the person just passed away, say they've been dead for a month, then you've still got 11 months to wait before you can transfer property. So you may want to go ahead and open probate in that scenario to get the ball rolling, get that 4-month creditor claim period rolling. Scenario 3 is if there's a will and the person has not been dead for a year yet, then you're probably going to want to open probate. That will's got to be authenticated if you're going to pass the property under the terms of that will. And if the person hasn't been dead for a year, then you would probably want to open probate to go ahead and get that 4-month creditor claim period instead of a 12-month. And then the fourth and final scenario is if there's a will and the person has been dead for longer than a year, then I'm back to that good old it depends. So if the will changes how that property would pass under state law, then you want to go ahead and open probate. And let me give you an example of that. So say I have a will and I'm leaving everything to my husband. Well, under state law, everything would go to my husband anyways when I pass away. So if I've been dead for longer than a year, there might not be a reason for them to probate that will because it's going to pass, everything's going to pass the same way under state law. So probate may not really be necessary in that scenario. But if I have a will and I say, I want to leave everything that I own to my nieces and nephews, well, that's not how it would pass under state law. And so that will definitely needs to be authenticated. So you got to open probate to do that so that it can pass to my nieces and nephews, which was my wishes, rather than to my husband, which is how it would be under state law.
Okay, that makes sense. That makes sense. And you mentioned the creditor period. So that brings me to my next question of whether or not a property can be sold or bought during the probate period.
Yeah, so short answer is yes, it can be. If probate's already been opened, then those documents that have been filed with the clerk and master will probably tell us who can sell that property. So we can go ahead and start the ball rolling.
Okay, and does that creditor period impact when they can close on the house and like when the new owners can take ownership? Or
yeah, that's a great question. So it doesn't impact when you can close. So the creditor claim period impacts more of when the sellers are going to get paid. So say you have somebody that's open probate a month ago. So you've still got 3 months until the creditor claim period runs. But we want to close at the end of this week. Well, that's okay. We can go ahead and close. We can go ahead and transfer ownership. But the title company is going to have to hold the seller's funds in escrow until that creditor claim period has passed. And the reason for that is if for some reason that estate becomes insolvent because there have been more claims filed during that claim period than the value of the estate, then the court has the ability to pull that property into the estate and make it an asset of the estate. And if that happens, instead of us dispersing those funds to the sellers, we would disperse those funds to the court, and then the court would decide how it gets dispersed. Okay. So that's why we have to wait that 4-month creditor claim period, just to make sure that we're not having to pay those funds into the court, but instead we can give them to the seller.
And you've kind of answered this question already about when a seller gets paid, but so exactly how long does probate last?
In the very least, it typically takes about 6 months. Okay. From the time that you open probate, you've got to wait at least that 4-month creditor claim period. There's always a little bit of, scheduling conflicts with the court typically. So you're probably not going to get out in there, that exact day of the 4-month creditor claim period running. So I would say about 6 months from start to finish at least. But again, we're most concerned about that 4-month creditor claim period running. That the probate estate can still be open and we can still give the funds as long as that 4-month period has run.
Okay, well, 6 months isn't that much of isn't that long of time. I know in a market like we've had recently, people are used to things happening, in a matter of 30 days, 60 days or less. But 6 months to deal with all of those nuances with the court system, that's actually not that bad at all. So what's the best thing for a realtor or a seller to do when they know someone's died, and how to move forward from there?
So the best thing that a realtor or seller can do is just let us know as soon as you know. So as soon as, sometimes your seller doesn't tell you all the details up front, so you may not know that this is an estate property. But as soon as you do, just let us know. That lets us go ahead and get to the probate court and pull those documents. Or if probate hasn't been open, seller can call me. I can kind of walk them through the steps that need to be taken.
Anything that they should try to ensure that they have on their, like, as part of a file or as part of documents that they bring to you to get the ball rolling?
So a death certificate is kind of key. We really need that. The probate court's going to need it too. So just make sure that they've got a certified copy of that death certificate. And then one thing that we always are going to have is a 10-care release. I have people tell me all the time, well, my mom didn't have 10-care. She wasn't on 10-care. I understand that, but per state law, we still have to get 10-care to send us a letter saying that nothing's owed to 10-care. And it's easy to get. It's just a form to fill out. So if they don't have that yet, that's a form that we can email them or we can help them fill out, and we can fax it to the state. So it's pretty simple process. During COVID, it took probably about 6 weeks to get that back, but now we're typically seeing those back within about a week. So that's something that we want to take care of at the start, just to make sure that that's not slowing us down later.
Okay. And for people that might be watching that are not from Tennessee, what is 10-care?
So 10-care is like the Medicaid system, basically for Tennessee. So if, for example, an elderly person is in a long-term care facility and doesn't have the money to pay for that, then but they do own a home, when the last spouse passes away, 10-care could have a lien on that home. So we've just got to make sure from 10-care that there's nothing that is outstanding that needs to be paid in conjunction with the closing.
Okay, great. Well, this is a lot of really good information, and I feel a lot more clear about probate after listening to you. You did mention this already, but I want to ask again for those people like me who it might have went over their head, or they may have been paying attention to something else at the time. Is an attorney necessary when starting or dealing with probate?
Yeah, so I get that question a lot, and it's a really good question. I definitely think it's a good idea to hire an attorney who has experience with probate. That's going to be the ideal situation. They can walk you through all the nuances. However, it's not required. So I know that there are scenarios where people just don't have the resources to hire an attorney. And in that situation, I always suggest that they go to the clerk and master in the county where the person who passed away lived, and talk to them, schedule an appointment with them. Generally, they are willing to walk you through. They'll give you forms that need to be filled out, and you can, take the will down there if there is a will, and they'll help you get everything filed and get probate started.
Okay. And that's the, what did you call it again?
The clerk and master.
The clerk and master, where the person lives?
Yes. So typically the court that handles probate is Chancery Court. Now, don't quote me on that, because there are counties where they give probate jurisdiction to general sessions or other courts. So you would just call the courthouse and ask who you need to talk to for probate, but typically it's the clerk and master.
Okay. And then to clarify, it's what if the property isn't the same property the person lived at? So should it be the county where the property is?
It's the county where the person lived.
Okay. Just wanted to verify.
Yeah, that's a great question.
Excellent. Well, that was a lot of great information. I really appreciate you taking your time out of your day to explain that to us. And if you want to take a quick second and tell everybody once again who you are and how they can reach you, and maybe even how they can follow Melrose Title.
Yeah, thanks, Ben. So my name is LuAnn Crass. I'm with Melrose Title Company. We have Facebook, we have Instagram, we have LinkedIn. So if you want to follow us on any of those social media outlets, we also have a website, melrosetitleco.com. If you need to reach me by phone, my number is 865-590-6360. And then my email is LuAnn, LuAnn at melrosetitleco.com. If you have any questions about probate, please feel free to reach out. I'm happy to help.
Awesome. Awesome. Well, thank you so much. And guys, thanks so much for watching, and we'll catch you on the flip side. Well, that's it for today's video. Thanks so much for checking it out. I really hope you guys got a lot out of it. I hope that she answered all those lingering questions. And of course, if you still have more questions, you can reach out to me. My contact information is in the description. Or you can reach out to LuAnn directly. If you didn't catch her contact information scrolling in the interview, it's also in the description. Thanks so much for stopping by, guys. I hope you enjoyed the video. And until next time, have a great week and have a great rest of the day. And we'll see you later. Bye.